Thank you so much. Before starting, please allow me to start with a disclaimer. I am a former Council of Europe employee, meaning that I used to work as a lawyer within the European Court of Human Rights, after which I decided to come back to academia. And ever since, I continued to collaborate with the Council of Europe, this time as an independent scientific expert for various of its bodies. However, all of the opinions I am sharing with you here today are mine and only mine. They do not reflect in any way an official position of the Council of Europe, nor one of any of its bodies. And with that in mind, let me start my presentation and share with you what I have defined in my research as 5 best practices in promoting the use of artificial intelligence applications in the field of justice. And very shortly, just to share the background that exists, also it was already mentioned by the previous speaker, so I won't go into much detail. We have witnessed already misinformation, right? As the fake news of Estonia developing AI judges, which went viral, and it was confirmed by the Ministry of Justice a few days later. Second, we've seen different types of misuse of artificial intelligence applications in the judiciary, such as the Colombian judge that proudly shared with us that he used ChatGPT to motivate one of his decisions. Maria already mentioned this before. Or we've seen what Antonella called as over-relying on technology, or what I call the fear of going against the prediction, which is absolutely natural because we don't understand the reasoning of the prediction, hence we cannot motivate against. And this can be the case of machine bias of Compass, which is an American system that predicts the likelihood of defendants to commit again a crime in the future. And it is actually being used by judges, including to prolong the sentences of the defendants. So it is against such background that the Council of Europe decided to take action through one of its bodies, namely the European Commission for the Efficiency of Justice, or otherwise known as the CEPEJ. This is a body that has been around for quite some time now. It was created in 2002, and it's supposed to improve the quality and efficiency of justice. Its aim is to strengthen the court user, or otherwise the public in general's confidence or trust in the judiciary. It is formed by a secretariat, which is based in Strasbourg, the 46 member states of the Council of Europe, but also observer states. And we have de facto all of the observer states before the Council of Europe, which are Holy See, Canada, Japan, Mexico, and the United States. But also other states expressed their wish to be observer states only before the CEPEJ. And these are Guatemala, Israel, Kazakhstan, Morocco, and Tunisia. Now, this body is best known for its biannual evaluation report. This is every second year. CEPEJ is telling us a lot about what is happening in the judiciary of its 46 member states, how things evolve or not in quite some detail. If you've never checked it, I highly encourage you to do so. But what role does the CEPEJ play when it comes to artificial intelligence regulation? Well, in 2018, it put forward a European charter for the use of AI in the judicial systems and their environment. And I will show you in a bit the 5 principles that were put forward. And it basically gave 4 years to its member states to understand to the best of their knowledge how to apply these principles in their practice. And then in 2022, the CEPEJ defined what it called a revised roadmap on how to apply these 5 principles. And in doing that, it understood to create an artificial intelligence advisory board, which was aimed or tasked to develop tools, but also to evaluate what has been happening in its member states. Now, one of the creation is a resource center. It's actually the work I've been doing with the CEPEJ, and what I'm going to show you in a bit, where they created a database of artificial intelligence applications currently used in the judiciary. But then they also understood to create a tool, which is basically a set of questions to which member states can respond, and in order to understand whether they apply correctly these 5 principles or not. Now, this tool is currently tested by the Council of Europe on 2 different systems, and it will be, if effective, it will be deployed also to member states. So I told you in 2018, the European Ethical Charter on the Use of AI in the Judicial System put forward 5 principles. Now, the first, of course, referred to the respect of fundamental rights. However, it was felt that non-discrimination should be set for, although included in fundamental rights, it should be strengthened even further in the context of AI. So it is the second principle. Then we have the quality and security of how data is being processed. And the fourth refers to the right to a fair trial, Article 6 of the European Convention on Human Rights, such as transparency, impartiality, and fairness. And the fifth principle refers to under-user control. And you will see that one of the best practices I am proposing here today refers to actually this fifth principle. So I told you that one of the decisions was to create a resource center on cyber justice and AI, and this is supposed to be a focal point containing reliable information on AI systems and other key cyber justice tools applied in the digital transformation of the judiciary. These other key cyber justice tools was decided because obviously not all the systems are AI. However, please know that the center does not imply any affiliation, endorsement, or recommendation of the presented systems by the CEPEJ in this resource center. Why? ChatGPT is part of this database, for instance, just to give you one reason. So it is an information, right? It has an informative purpose. Now, when we started this work, our human prediction was that at best, we're going to find 50, 60 AI systems, of course, with a focus on Council of Europe member states, but then we enlarged our area and we actually looked worldwide. Very fast, like between 2 or 3 months, we achieved more than 150 systems. Now there are over 200 systems in the database. However, 125 are currently publicly available. Why? It is the advisory board that decides which systems are going to be published or not. And for instance, one of the criteria is for the system to have been used for at least 1 year. Therefore, really recent systems are not currently in the database. Now, at this moment, it contains 8 areas of application. It used to contain 9. E-filing was also included. Now it is no longer included because it was decided that it does not fall within the purpose of the resource center. So let me share with you quickly what the areas of applications are. So the first one is document search, review, and large-scale discovery. It refers obviously to searchable collection of case law descriptions, legal text, and other insights that might be useful. The second is online dispute resolution. The third refers to prediction of litigation outcomes. The fourth refers to decision support and is supposed to facilitate or automate stages in the decision-making processes. The fifth refers to anonymization and pseudonymization. The sixth is triaging, allocation, and workflow automation. The seventh refers to recording, transcription, and translation, and this used to be called natural language processing. So you can also see how the work of the advisory body evolves and how we try to best define things. And the eighth is information and assistance services. And these are services that basically provide individual or the public at large with information on services available to them in the justice system, but also it links them with these services. Now, as I told you, there are a total of 125 systems in the database, and here you can see the areas of application. So currently, as you can see, decision support has the biggest amount of systems currently developed. It's 41. Then we have 38 in triaging, allocation, and workflow automation. And then 32 document search, review, and large-scale discovery. For instance, prediction of litigation outcomes, it only has 3 systems currently in the database. Then if we look at the target audience, we see that currently there are these categories defined: judges or clerks, court users or the public, the general in public, management, lawyers, prosecutors, and bailiffs. And you can see also the numbers here. And when it comes to implementation, this was also modified from the initial way we understood to define the implementation. It currently contains public authority, academic, and private provider. You will see that public authority has, 117 systems, but please note that here are included mixed collaborations. So public and private collaborations are currently included within the public authority field. Then I took one example and I decided to go with Italy and to share with you that there are currently 8 systems published in the database. Italy is one of the pioneers in this sense, and there are more in the database, and Claudette and Adele are part of the database. As you can see, half of them are developed in academia and half by public authority. And basically, there are 4 decision support systems, 2 triaging, allocation, and workflow automation, and 2 document search, review, and large-scale discovery. Before I go into my preliminary analysis, let me tell you that this data was gathered from the European Cyber Justice Network, which is a network that collaborates directly with the CEPEJ. It's formed from either judges, prosecutors, or representatives of the ministries of justice. So the data came directly from domestic authorities. And let me tell you what my preliminary analysis is after having collaborated with the CEPEJ on this. I believe that there's a worldwide dissemination of AI tools in the field of justice, and they are much more than we expect. As I told you, 125 are published today. However, more than 200 are part of the database. There is a visible uneven effect. First of all, there's a discrepancy between global north and global south. And second, there is a discrepancy at various levels within national systems, and sometimes even a lack of communication. We had a case where at national level, there was no knowledge of what was happening locally and regionally. So we had to wait for them to get informed. It is very possible that there will be disadvantages of disparate usage. And why? Because I think in time, it's going to be a problem to correlate information between tools. And this is the case in Italy, because some courts developed exactly the same type of application by themselves. But then maybe in 5 or 10 years, we're going to decide that we need them to collaborate, but the systems are completely different. So that's going to be something that I think member states need to think about, also about the future, not just how we want to facilitate our work right now, but how it's going to affect in the future. Of course, I'm sure that you're aware of this. Not everything that is called AI is AI. And I think member states, it was the first question, what do you understand by AI? We have no idea whether this is AI or not. So there's, I think, still a need to clarify. This is why we went for areas of application, and this category of AI and not AI was decided to not be part of the database, at least for the moment. And here come my 5 best practices. I think there's a need for member states to coordinate with the CEPEJ in order to ensure an effective implementation of the Charter. Second, I think there's a need to establish a right to opt out, and this refers to the 5th principle of the Charter. And at least for the moment, this is how I understood to define it. First, I think everyone should be entitled to be informed of the use of an AI application in judicial proceedings in which them are involved. And second, I think they should be entitled to opt out if they want to do so. Third, of course, it was already mentioned that there's a need to still provide trainings, both to judicial operators, but I do believe that also court users should be allowed to have the opportunity to train. Fourth, if exposed to an AI application in judicial proceedings, I think a party should be allowed the time to familiarize themselves with its feature, for instance, in the case of video conferencing. And fifth, I think it would be great if it turns out that the evaluation tool proposed by the CEPEJ is actually effective and member states will use it to understand if they apply correctly the 5 principles or not. Based on these premises, I want to share with you what my research questions are in the moment, and what I'm going to develop next is how does the deployment of so many AIs affect the independence and impartiality of justice? How does this relate or translate to the rights of court users? Are the substantial and procedural requirements of effective remedies still met? Before thanking you for your attention, let me tell you that CEPEJ would greatly appreciate if you would share with them if you know of any new AI applications used in the judiciary. And I have hyperlinked the form where you can share directly with the Secretariat if you happen to know of such a use. Thank you very much.